Business Development Manager and the incubator. So we're very happy that Tom Tony has agreed to come with Archie Bay and talk about IP points.
So by a show of hands, who here is part of a startup company right now? Everybody. How many of them are biotech? Software? Professional services? Electronics, okay. How about you guys? What do you guys do?
We're Circle Life Doors.
Oh, hello. Hey, how are you?
Hey, nice to meet you.
You actually manufacture products. That's rare now. Okay. So this is about tracing the IP or identifying the IP you didn't know you had. Everybody's heard about patents, trademarks, copyrights, trade secrets, but they don't necessarily know what they are, and they don't know what they have. And my philosophy is that everybody who's gone into business for themselves has some intellectual property. Whether it's something that can be protected in a patent or trademarks or copyright, that stuff will there. So everybody has some kind of intellectual property. So what is intellectual property? These are other people's definitions. You can tell that I don't call it like that. But they're creations of the mind or the intellect that can be legally owned. So that's the actual nebulous concept. The other definition is the laws that we have created around those creations. And again, they generally fall into patents, trademarks, copyrights, or right of publicity. Is anybody here famous? Okay, and I'm not spending time on that. And trade secrets. This is my definition of intellectual property. It's whatever it is that is intangible that gives you an advantage. And these are the three questions that I think are very useful in identifying your intellectual property. If you went into business for yourself, or if you're involved with a startup, there's a reason you did that. You thought you could do it better. You had some advantage over people who have been doing it before you. Has anybody here created a new industry? You created a whole new industry? Okay. So I mean, everybody here has competition, but you went into business because you said to yourself, I can do this, I can do this, and I can do this better than they can. People would rather work with me than with them. And there was something about that. Now, it could be a tangible asset that gives you that advantage, and that's obviously something else. But for most people, it's going to be something that's intangible. So okay, here we have I'm going to go over the basic groups. You have patents. There are utility patents. Those are what most people think of when they think of patents. You've come up with a new gadget, a new wiki, a new way of doing something, a new chemical. That's what's covered by utility patents. Then there are design patents. Design patents cover the way your doohickey looks. Nothing functional about it, just the way it looks. A really good example of a potential design patent would be the Aunt Jemima bottle. Okay, it's a functional device that looks like a lady. It doesn't work better because it looks like a lady. Matter of fact, it probably works worse because it looks like a lady. But it has a very distinct ornamental design, so that's something that could be protected by a design patent. Copyrights. Those are works of authorship. Things you normally think of: books, movies, sound recordings. Also architectural works, which a lot of people don't know about. But the catch there is it has to be a fixed expression. So the copyright and the patent do not cover the idea. So for example, in the patent, it has to be useful. So it has to be something, an implementation of something. And for copyrights, there has to be a fixed expression. Trademarks. Everybody see where I'm going with the level?
Can I ask you a quick question?
Sure.
Are you going to go into a little bit more detail on each one of those patents, copyrights, trademarks?
Yep.
Okay.
Or we can spend it.
Okay, because the question that I had, and you can reserve the answer to that, is like, you put like the little C circle on stuff.
Yep, you go roll that.
I mean, is that copyrighted? I mean, is it that simple, or do you have to have
Yeah, no, yeah.
Okay.
Trademarks identify the source of a product or a service. And so they can be anything, it could be a word, it could be a phrase, and those are what we're used to thinking of when we think of trademarks. Disney is a trademark. Happiest place on earth. Tagline, that's also a trademark. Logos are used to colors. The colors are not as prominent as people seem to think they are. But there's even sounds and scents can be a trademark. So if they are used properly, it's really anything that sets one product apart from another product or service. Trade secrets. One of the big misnomers about a trade secret. It's actually not misnomer, it's a misunderstanding. It actually has to be a secret. Just because you don't want people to know about it or don't want to use it, that's not enough. It actually has to be a secret that gives you some kind of economic value. And it can be pretty much anything, as long as it meets the requirements, which we'll get into later. But not too much that I haven't seen some people try to squeeze into a trade secret. So these, all together, add up to what people commonly think of as intellectual property. And this is where I think intellectual property comes from. So there's the four on the bottom, and then on the left-hand side, we have what I just dubbed intellectual assets. They have a value to you, but there's really no meats and bounds around them. And you can just see a list of something that most businesses have. And they're very valuable to you. But they don't know how or if they can protect it. And so you have intellectual assets and human capital. And those two are really almost, I'm going to talk about everything in the context of those four. But the list on the side, those are the things that I'm really referring to when I say intellectual property you didn't even know you had. So, your customer list can be important, your vendor list can be very important. It can be very important knowledge that, depending on what you do, isn't really available to everybody who's just watching you. And that can give you, if you have found a great way to cut the cost because of your vendor list, that's a tremendous asset that you want to protect. And then over here, this is the one I think gets missed more than anything else. It's the human capital. And the human capital is what gets lost the most. Is everybody familiar with the term technology transfer? Universities have technology transfer departments. The whole department, the purpose is to take information or to take intellectual property and try to give it to somebody else in exchange for money. They're doing it on purpose. There is something else called informal or unintentional technology transfer, which happens much more frequently. And it's very similar in that the information flows, but the money doesn't come back. And so that's where most of that flows. It's with the human capital, because there are very few companies and very few endeavors where you're going to be able to do it all by yourself. So let's start with the patents. So we have the utility patent. That's for things, widgets, methods, processes, business methods, all but been done away with. But even software falls under the utility patent.
Can I interrupt? On the previous slide, on the bars on the left and the right, intellectual and human capital, do they in some way fall under the four types of intellectual property?
Yes, and that's what I'm going to try to do. By giving you an overview of the four, I want to show you how all those things can flow into these four, and possibly not fall into one of these four, but still what you can do to protect it if it doesn't.
Okay.
So, okay, we have the utility patent. The whole point of the utility, it's supposed to last you about 17 years. You actually get 20 years from the day you file. And when they made that rule, they guessed that it was going to take you 3 years to get it filed. It doesn't turn out that way. It's probably a lot less. But that's the issue. Then you have design patent. But even though it's ornamental, I mean, there are some requirements. It can't look just like something else that was out there. And then we have the plant patent. We actually make a new asexually reproducing plant. Does anybody here do that? Good, because I know nothing about plant patents. It's never come up. I've been doing it for 10 years, and no one's even asked me a question about it. So okay, here we go. We got these are the defined areas: processes, methods, machines, articles of manufacture, compositions, or any useful new improvement thereof. So there might be something out there that you like or you want to build a business on, and has a patent. You can improve that, and as long as your improvement is patentable in and of itself, you can still make that your invention. And then you can patent that improvement. Now somebody else will be able to practice the old system, but you'll be able to stop them from practicing it with your improvement. And if the old gizmo is still under patent, then you will be responsible to that patent owner for royalties. But you can still, if you're selling a superior product, you can charge more for it. So from your standpoint, you have to come up with the invention. It has to have utility, it has to be novel, it has to be non-obvious. And then once you've done that part, that's the easy part. I have to write it. But I just have to make sure that it's enabled. So this is how you know when you have an invention. It has to be enabled to the point where I can pick it up, or you can describe it to me with enough detail that I can write about it in a way that somebody who does what you do can pick it up and practice the invention or make the invention, or that's the deal. Because as part of the capitalist society, we don't really like monopolies. But the deal is the government will give you a limited monopoly in exchange for telling them or telling the world how to do this new cool thing. So they'll give you a limited monopoly of that, so that when your patent expires, the world is now a better place because everybody has this knowledge. So before you can move on, so if you have a great idea, and it may be useful, it may be new, and it may be not obvious, but you're going to have trouble protecting it unless you can give me the information I need to do my job. So that's really the critical step from getting past the idea into getting to an invention. So here's an example of utility. Utility used to be a very easy bar to get over. Matter of fact, there was a case where somebody had a hat for horses, and I don't know, I said, no, this is stupid. And then they took it to court. Court said, yeah, it's stupid, but it's funny. So that alone was a use. That was utility. It was a funny hat for horses, and they got their patent. What you can patent, though, are laws of nature. And this is a little bit more important now than it used to be, because this is what they're using to turn down a lot of software patents. So if anybody is in the software industry, they spend a lot of time trying to talk people out of filing software patent applications. Very expensive. They take a long time to prepare. They take a tremendous amount of time to prosecute. And even when you come out the other side with a patent in your hand, the courts treat them very harshly. So this is an example of what utility is. Everybody knows that what Ben Franklin, we have the kite flying. I think most people don't seem to understand is that you got the string of the key. The critical part people miss is that you had a wire going from the key to the ground. So there's a laundry list of people who died trying to recreate the experiment, and they didn't have that wire going from the key to the ground. What he discovered, he did not discover electricity. Everybody knew what electricity was. Everybody knew that lightning was really bad. Matter of fact, it was a plague. In colonial times, there were all these buildings that were made out of basically dry tinder, and the lightning would hit, and the entire city would burn down. But what he did discover was he discovered that lightning traveled in electrical current. That's still not patentable. Lightning is comprised of electrical current. However, the lightning, taking a metal object, putting it as high as you can, with a conductive element going from the wire to the ground, that's an application. And that would be patentable. He didn't patent it. He's a hippie, and he thought it was too important, and he wanted everybody to practice it, and I guess that's why he had enough money. So I'm not a big fan of practicing